Deputy Lowry 6.5.
Thank you. I welcome the opportunity to speak on the matter because it is a very concerning issue. But first of all, I'd like to commend those who have helped bring it to light in the fashion of which we're discussing it today. And in this case, it involved the state, what was involved was the state bullying into submission those who couldn't afford the risk of high legal fees to seek justice and compensation. Those people who were wrongly charged but either hadn't the means or the knowledge to go about seeking redress. And instead of protecting them and serving them, we have politicians and officials strewn throughout this debacle trying to manipulate those people into silence and submission. Now, I have read the Attorney General's report a number of times, and I think it's fair to say that my concerns have not been alleviated by it. In paragraph 2, it says that this account has accordingly had to be prepared on the basis of documentation readily available and within a very compressed period of time. What documentation was readily available, Minister? And more importantly, what documentation exists that was not readily available to the AG? Paragraph 9 states, the period of time covered by the issues of controversy addressed in this report includes an era in which the government's finances were very strained. Other than the strain on government's finances at the time being irrelevant, how much did it cost in legal fees for settling these cases? Paragraph 13 says paying for the choice by citizens to take up beds in private nursing homes was, put simply, a brief that the state never agreed to provide for its citizens, and legislation passed by the Oireachtas in 2006 and 2009 reflected this policy choice. In this report, it's suggesting that the case at the heart of this issue arose out of a choice to go private. It was my understanding, and that of everybody that was involved, that some people ended up being placed in a private nursing home because the state were unable to provide a place in a public one, and that such a test case has not been determined or brought before the courts. Paragraph 14 says, the irresistible logic of such a perspective is that the state has unlimited resources and must concede every court case that is brought against it and must fund every claim for compensation or redress that is demanded of it. This is not a typical compensation case, Minister, nor is it a typical redress and should not be framed as such. It's a case where the charges were taken in a way that they should not have been taken, and where the government at a later date were prevented by the Supreme Court from making changes retrospectively in legislation to make those charges legal. So by no means is this a typical compensation or redress. Paragraph 95 to 98 highlights that in 2004, the government sought to validate the maintenance charges which health boards had imposed. And the only reason the government in 2004 would seek to validate these charges is because that they were previously invalid. Acting ultra vires. This in itself is an admission that the charges should never have been taken from people in the manner of which they were. And paragraph 171 references the safeguardings of monies. The phrase is disingenuous, and it's the most disingenuous way of describing this situation. This is not typically compensation or redress, and it shouldn't be framed as such. It was monies illegally gathered by the state that should have just been paid back. There shouldn't have been a debate. The strategy is a common one, as we now know, within mysterious workings at the back streets of government departments with files that are labelled secret. And if it is a regularly used strategy, let's hope that others will have the brave wherewithal to come out and blow the whistle and shine the light. Unfortunately, the Attorney General's report merely raises more questions than it answers, and I'll be calling for an independent inquiry to be established into this whole affair if the 3 months in the interim that it's to be discussed doesn't provide the answers. It's an extraordinary day when government seeks to hide behind the statute of limitations to deny the most vulnerable in society what is rightfully theirs. The statute of limitations is a bargain basement defence that should be afforded to the most marginalised in society, not one that the big government can rely on to screw poor Joe and Mary. The Attorney-General's opinion may be legally correct as of today, but it's morally reprehensible, and it's one given in a rear-view mirror, and relying on the statute, if it were in today's realm, would be way, I can't even provide words. But as Fintan O'Toole put it in the Irish Times on Tuesday, the Department of Health did not challenge those who refused to pay nursing home fees. It hammered only those who were too poor to hire a lawyer. And most of the people affected by these charges are no longer with us, but they have family members and loved ones who had to pay through the nose in many cases and rid themselves of assets to provide for the care of their loved ones. And they deserve to be treated with dignity and respect. And at the moment, the state is not treating them in any way. Thank you.